And welcome to the Week 8, Chapter 8 video lecture. In this chapter, we're going to talk about judges. As you know, we talked about prosecutors, we talked about defense attorneys, and now the last of the courtroom work group we're going to talk about in some detail. Let's go over what we're going to learn. First, we're going to discuss the role of the judges within the courtroom work group, and we'll see that they have their own agenda, as the prosecutor does and as the defense attorney does. They have their own goals and policies and so on. And so they act a little differently than the other two, but they're all very much involved in the courtroom work group, and they're the ones that have the most to lose, perhaps, because it is their caseload that they have to manage. It's not the caseload of the prosecutor or the caseload of the defense attorney so much as it is the judge, who is often judged based on how well they handle their caseload. Number two, we're going to name three major ways that judges are selected in the United States, and we'll see how those ways can, lead to different kind of characteristics of the judges who are selected. And I'll be asking questions of you, which do you think would be best? And those are sort of rhetorical questions because there is no definite answer, but I want you to think about it because, how our justice system works depends on who gets selected as judges. Number three, we're going to analyze the consequences of different methods of jury selection. We're going to actually see some of the advantages and disadvantages of those systems so we can get a better idea of how maybe what's best or what's not best. We're going to then recognize major changes in the composition of the bench over the past several decades. We'll see how it has changed, and at least in major ways, over what it was, in the, say, first half of the 20th century. Let's look at also describing the activities of the state judicial conduct commissions. We'll see that, yes, you could probably recall a state judge because they are an elected position, but that is extremely cumbersome, very difficult to get started. Most people don't really know what judges do, so highly unlikely that you could probably even get that process even started. And so it just doesn't work if you have a bad judge. You're not going to get them out through that process. It just doesn't happen. So most of the states have opted for the state judicial conduct commissions, and they oversee these judges, with the state Supreme Court being the final arbiter of what would be done with a judge who's been found to have been involved in misconduct of one sort or another. Also, we're going to explain the difference between impeachment and the removal of a federal judge. And we'll see that for federal judges, the only way they can be gotten out of their position is through impeachment, for the most part, unless there's some other basis like incompetence. Maybe they become mentally ill or something, or mentally incapacitated. Impeachment would be the only way. Impeachment is basically for high crimes and misdemeanors, and without those, basically a federal judge can do whatever they want, which is one of the problems of having lifetime tenured judges, but that's the way it goes. All right, let's look at the powers of the judge. First, they have the power over the entire case from the arrest through the disposition. And in fact, they often will have quite a bit of powers over the investigation. If it needs search warrants, if it needs judicial power in some fashion to do things that police cannot do otherwise, then the judges would be involved. They also set and they revoke bail. They preside over the trials. They also have sentencing authority in most states. And in some cases for death, for instance, it has to be both the judge and the jury that vote for it, and it has to be unanimous. But otherwise, they have pretty much unfettered discretion over everything except death cases in most states. Let's look at some of the benefits and frustrations of the job. First, the salaries are often high. Yes, they are high in the sense that, a federal judge, I think, is something like $175,000 and $185,000 a year, which is not bad, by the way. But when it comes to attorneys of that caliber, in the real world, outside of it, they can make a lot more money than that. So it's actually not, from their point of view, a high salary. It's actually sort of a mediocre salary. But it offers the fact they don't have to get clients in the door, and there's, it doesn't go up and down as these salaries will do in private practice. They can also appoint friends to various positions. For example, a judge may be entitled to a clerk and a law clerk that they can appoint entirely on their own. Maybe even a court attorney can be appointed by the judge. And it's those people are at will, so they can come and go. And they work for the court, but each judge that has one is allowed to choose them on their own. So they can appoint some of their friends, hopefully people who are competent, but maybe also someone they like. But that's just one of the benefits. Nothing wrong with it as long as they're competent and they know what they're doing. Some of the frustrations of course, heavy caseloads, that's almost universally true. You don't see a lot of court judges out there who are looking for work. I mean, unfortunately, I don't care what court it is, even the smallest court has more cases than there's time to do. There's many administrative problems also. How do you make sure that some of the problems that are going on in the court, like for instance, the court might be falling apart. The courthouse might be falling apart. There's no money to fix it. Well, what do you do? I remember one time in Orange County, when Orange County had the big problem with their pension system that cost them so dearly that they were cutting back on everything. I remember one of the judges in Orange County saying that he told jurors in his courtroom that if they didn't, if they had a complaint against the janitorial services for the cleanliness of the courtroom, that they are to bring that directly to his attention because he was the janitor. There you go. There's an administrative problem. He had to clean his own courtroom. Why? Because they fired all the janitors because they're trying to save some money to pay back on the losses in the pension system that they had. They almost sent them into bankruptcy. They're called a politician, an administrator, a bureaucrat, and a lawyer all in one. And they have all those characteristics. That even is true for federal, where they're appointed for life, because you had to have a lot of politics involved in your position in order to get appointed as a federal judge, because you have to be appointed by the president. So you better have some political connections. You have to administrate a very, very heavy caseload. You have to deal with a bureaucracy that without it you wouldn't be able to function. And then you're a lawyer trying to do the best job you can in the cases that are brought to your attention. All right, let's look at the role of judges in the steps. When it comes to arrests, the lower court tends to sign the arrest warrants. Often will sign the search warrants as well. Sometimes those two go together. In the initial appearance, the lower court will inform the defendant of pending charges and appoints counsel for indigence. The major trial court will actually just do the trial, typically. The appellate court issues opinions and the final word on interpreting criminal laws passed by the legislature. They often wrestle with legality of police arrests in context of questions of illegal searches and seizures. They deal with just simply questions of law entirely. They don't deal with the actual fact finding that you do in the lower courts and in the trial courts. They simply look at whether a fair trial was given. Well, first, whether there's any error of law in the trial, and then whether the error was harmless error or not, and whether it should be reversed or not. On the issue of bail, of course, the lower court will set bail. The trial court can alter it, and appellate courts rarely will decide that issue because it's a factual issue. Often the trial court can set bail, pending appeal, and then it's there until the appeal is over. That's why it's very rare for appellate courts to deal with bail. The charging decision, of course, there's no authority in the lower court, no authority in the trial court, and no authority in the appellate court. That is not a function of the judicial branch of government. That is entirely a function of the executive branch of government through a public prosecutor. The preliminary hearing, of course, often is decided by the lower court. They will then send the case off to the major trial courts for trial. Appellate courts, of course, have no trial and have no preliminary hearings. Grand juries are essentially supervised by the major trial courts, and the reason for that is because if they return a true bill, which is essentially an indictment, then it would go to the trial courts because it'll bypass the lower courts altogether, go directly to the trial court because it is a preliminary probable cause hearing, and if probable cause is found to be true, then the case goes off to the major trial courts. Then arraignment, of course, comes in on the indictment or on the holding order from the lower court for a preliminary hearing. And then the major trial court will inform the defendant of the pending charges. They will arraign them essentially on the charges. Then on the evidence, of course, the lower court will review and authorize search warrants. The trial courts will then rule on suppression motions involving illegal searches and seizure and custodial interrogation. They will also rule on what evidence comes into the trial and what does not come into the trial. And the appellate court will actually establish rulings and boundaries for search and seizure and custodial interrogation, other aspects of whether evidence should have come in, should not have come in. And they can reverse a case, for instance, because someone let in evidence they shouldn't or did not allow in evidence they should have. Plea bargaining, of course, judges rely on pleas to dispose of items on large dockets, and lower courts will be involved in it. And some judges in the trial courts will also actively participate in doing exactly the same. But the appellate courts rarely involve plea bargaining of any kind. They just do their job of finding out whether there was an error in the trial court, and that's it. Trials are rarely held, at least in felony matters, at the lower court. Misdemeanors would be filed there and tried there, but not felonies. They would be tried in the major trial courts. So the major trial courts would preside over the trial, rule on admissibility of evidence, instruct the jury in the law, and allow the jury to make its decision. They will enter the verdict and so on. They will hear pretrial and post-trial motions, and that's about it for what they do. The appellate court will decide whether the evidence was properly admitted, decide whether the trial court properly instructed the jury in the law, and if there were any other kinds of errors that may have gone on in the trial, and then whether or not those errors would have resulted in something less than a fair trial. For sentencing, lower courts, if they are going to be involved in sentencing, because let's say someone pleads before the preliminary hearing, they would typically impose, basically normal, unquote, normal set of penalties because they essentially don't want to, be inconsistent. They also, since it's a plea bargain, it's not something that causes a lot of grief to the judges if something bad happens because, it's a plea negotiation. Prosecutor agreed to it, the defense attorney agreed to it. Highly unlikely it's ever going to become controversial. Major trial courts then will increasingly deal with very potentially difficult issues of sentencing. It's one that where you may not have an agreement between prosecutor and defense attorney, so now the judge is the one and only authority here. If the judge either doesn't allow a plea bargain to come through or allows a plea bargain to go through that is not good because maybe it can end up getting somebody out of custody more quickly than it should, it's going to come back on the judge. So they tend to be very to deal with those difficult and controversial tasks much more judiciously than the lower courts. The appellate court in some jurisdictions must interpret sentencing guidelines, and that's a possibility that they can reverse a sentencing based on not following those guidelines. That's especially true in the federal courts. On appeal, it's rare that you have appeals to the lower court, except in some driving under influence convictions, where a lower court will sit as its own appellate court. And for the trial courts, you have to file a notice of appeal in the trial court in order to get an actual appeal of a verdict from a trial court to the Court of Appeal. And the appellate court will rarely reverse trial judges, but they do when something bad goes on that gives somebody something less than a fair trial. So let's look at some of the powers of the judge. Do you think they have too much power? Remember, they basically can do whatever they want. They can issue search warrants, arrest warrants, even if there maybe isn't really probable cause to believe somebody did something wrong. They can decide on cases. They can actually decide that a prosecutor's criminal count, one or more of them, is unjust or unfair and dismiss it. Yeah, they could do it. It would be very controversial if they did that. You have a prosecutor that's going to be screaming up and down, and the media is going to get their hands on it, but they can do it. Those are pretty heavy powers. They can decide someone's going to be in custody until that case is over with, and by revoking bail or not even allowing bail. They can do all sorts of stuff. They have the power. They have the power to interpret the law, and what the judge says the law is basically is the law, because there's nothing other than maybe an appeal, or you can set it aside if you're lucky. it's going to be what it is. It is what it is. And the judge is the one that says what it is. And I've often said, the law is what the judge says it is, even if I think it's different. All right, so what are some of the decisions that judges make? Well, they make every kind of decision in the case there is. First, they decide on whether there's probable cause to believe someone committed the crime, so that in a preliminary hearing, for instance, they decide on whether a person is going to be given bail and how much, whether an arrest is going to take place or not through an arrest warrant, whether a search is going to take place by a search warrant. They make all the decisions on the admissibility of evidence in the trial. They can exclude evidence that perhaps shouldn't be excluded. They can let in evidence that probably shouldn't be let in. All that kind of stuff. And then they have pretty much unfettered sentencing discretion in most states. So how harsh of a sentence can they impose? Well, there are sometimes legal limits, but they can give the high end of all those limits if they want to, if there are limits. And then what factors lead towards a more harsh punishment? Well, we look at many different factors, but usually it's the aggravating factors such as, whether the person has a prior history of this kind of crime or any kind of crime. How much of a criminal do we have here? Is this a first-time person, never been in the system, they're 60 years old? That's a bit different than, someone who's 18, already doing some heavy crimes. They're going to get hit really hard. Why? Because if we're going to ever change them, we're going to have to change them real fast, because they're on their way to becoming, doing their what we call life on the installment plan, and many people are going to get hurt. So there's lots of different decision-making powers that they have, and they can, you get a judge on a bad day, got out of bed on the wrong side, you're going to end up with a sort of a hanging judge kind of attitude, and that's just part of the power. So think about that in terms of whether that's the right thing to do. All right, this also thinking about Judge Ito. That was the judge of the O.J. Simpson criminal case. He had a serious problem after that case was over with. He was faulted for the fact that that did not go to a conviction, because what was happening is the people in the audience, television audience, were seeing everything that was going on in the case, and the jury was not. That's the reason why that case did not go to guilty by the jury, but was essentially guilty in many of the minds of the people who were watching it, because a lot of the evidence that the prosecution wanted to get on was not allowed in by Judge Ito, and that obviously would have contributed to why there was not a guilty finding or a guilty verdict. And so now Judge Ito got blamed for the going to not guilty. What powers did he use? The same powers that every judge has to make all those decisions, whether it comes in or it doesn't come in, whether bail is given or not given, whether there's an arrest warrant or no arrest warrant, whether there's a search warrant, there's no search warrant. It's all the same stuff. What benefits did he have as the judge of this case? Not very many, actually, because highly unlikely, unless it went to a guilty and everyone sort of thought he was a good judge, in which they would simply give a neutral opinion of him. He's a good judge, he did what he's supposed to do. But there was more than a likely chance that he was going to be found to have not done things well, and that was going to hurt him. And in fact, he almost did not get elected in the next election based on what happened in the O.J. Simpson case. He just nudged by. And that's really unheard of, because most judges never have a problem with being reelected, because nobody knows that, whether they're a good judge or they're not. And so they always vote for the one who's judge, and it's never been a problem. But it was for Judge Ito. What frustrations did he have in this case? Oh, many. He had a defense that was doing unimaginably unethical things, and he had to deal with it. And he made some very, very harsh rulings on them, including not allowing them to bring in certain evidence because they did not disclose it to the prosecution. And those were hard decisions. He knew there was a possibility that he could be found to have made an error on that, and the case sent back to him for trial again. So he had a lot of difficult decisions to make, no doubt about it. Let's look at the judges within the courtroom work group. They are often constrained by the actions of others. So for instance, if the prosecutor doesn't make an offer, the defense doesn't accept the offer, then really the judge can only try to make an offer with the defense attorney and bypass the prosecutor. It's not easy to do. The prosecutor might tell the judge, you go ahead and do that, but if you do, I'm gonna scream bloody murder when I get out there to the press, and you're gonna have to deal with the fact that you're giving up on somebody who really needs a bad sanction. And so, when bad things happen here, it's all coming down on you. It's that kind of problem. And if you're an elected judge, you want to be reelected, you think about those things. Okay, same thing now is true. Defense attorney won't agree to anything. Prosecution makes a real reasonable offer. Judge can say, that's okay. Let's go to trial, and just remember, I have ultimate sentencing authority, which is like an implied threat. That you think you know what I'm going to do. Well, you have no idea what I'm going to do, and so watch out, because maybe you're going to find that you're on the wrong side of this. But they're constrained by that. If there's no agreement between the prosecution and the defense, it's very difficult for judges. It's even difficult when there is an agreement sometimes between the prosecutor and the defense attorney, because the judge may say, I'm sorry, I don't like that deal. I'm not going to allow it. And they sometimes have to do that because they're just not going to be a party to that kind of a deal. Sometimes that happens, by the way, not out of any corruption, but because the prosecutor doesn't think as much of his case as maybe the judge does, and is trying to deal it out at something much less in order to not have to try it, because they might lose, and the judge doesn't like it. If you've been accused of this kind of crime, let's go to trial, because I want to have no constraint on my actions, so I can do the right thing. The judges can also award sanctions. They are the most powerful member of the work group because they have so much. They can essentially they can override the prosecutor. They can override the defense attorney. They give verbal rebukes to people. They use use of power. It varies, of course, as to the judge, but attorneys don't like being chastised by the judge, and especially not out in an open forum where everyone's there to see it happening. And so, that's another aspect of what they can do to try to get people to do what they want them to do. So, you won't see a prosecutor trying to rebuke the judge or the defense attorney doing that, because they'll be found in contempt and put in jail for doing that. But the judge can do it, that's for sure, because he's the judge or she's the judge. They can do what they want. All right, judge shopping is something that goes on. If you know of a certain judge and they have a certain prejudice as to your case, whether you're defense or prosecution, you can sometimes be assigned to that judge, but you can bump them. Usually there's one right to bump a judge without even a reason in most court systems, and so there's some judge shopping that goes on as a result, and that happens, and I've done that before myself. I had one judge on a very important case. He was just I thought he was a complete idiot. He didn't know what he was doing. I had a very complicated case with lots of legal rulings. I said, oh, no, he's not hearing my case. I bumped him immediately, and I had one right to do that, and I did that, and got a judge that was very, very good. All right, varying loads to a judgeship. Varying roads, excuse me, to the judgeship. First, it's possible you have executive appointments, such as the president appointing federal judges. That's the lower court, district court judges, and the appellate court judges, and of course the Supreme Court judges, as we're seeing more recently. There are also partisan elections. Sometimes judges are elected. Sometimes there's nonpartisan elections, meaning that there's no party involved in the election. It's just based on the merits of the people involved. And there's also a merit selection process in the Missouri Bar Plan, where they actually go through and try to select who would be the best based on qualifications. If you have a partisan election, qualifications mean nothing. You don't have to be an attorney, for instance, to be a judge in most states. So it could be anybody that can be a judge. Let's look at executive appointments. Nominations to the federal bench are all done by the president. There's also a role of the American Bar Association and other interest groups in deciding on who are the appropriate people to be appointed, and that they just help essentially in going through the qualifications of everyone involved and making their own recommendations. But again, it's entirely up to the president. It is definitely a political appointment. It always has been and always will be. The nominations to the Supreme Court, of course, are all by the president, and that includes, the district courts, appellate courts as well. There are executive appointments in the states as well. Some positions of judges are appointed by the governor, and some go to elections. It all depends on what the rules are in any given state. But many judges are elected. And that means they essentially have to go through the political process to become judge. And that's a difficult process. It makes them also think about their decisions differently than a lifetime tenure federal judge. Remember, all federal judges are lifetime tenure. You cannot get them out except by impeachment or through finding that they're incompetent in doing their job. And that means that essentially they can do whatever they want. They can make any decisions they want. They can be reversed as many times as they want. You can't get them out. But the political elected judges, they can be voted out at the next election. They can even have a recall election, but again, that's very, very difficult and is not usually done. Well, let's look at the election of judges. The majority of states elect their judges. Judicial election is uniquely an American invention. It's just not around in other places. This concept emerged during the Jacksonian era. That's with our President Jackson, as part of a movement to democratize the political process. And then some elections are partisan, whereas others are nonpartisan. Voters can be educated and disinterested. Typically, that's what they are. At least uneducated as to the qualifications of the people involved and what their thought processes are. There are different kinds of judges out there, and they have different policies, internal personal policies on how things should go, and those will get into their decision making as well. And few lawyers want to challenge a sitting judge, and so you don't necessarily get who might be the most qualified in terms of the abilities to be judge, and also they don't pay as well as you can make in private practice. So there's little incentive to become a judge if you're a very, very good attorney making lots of money. Recently, judicial elections are getting more unpleasant because they're becoming more and more partisan. More and more people want the job, and it's because there's a sort of a ladder that you go on if you want to be getting into the federal appointments and so on. It would be nice, for instance, if you were on a state appellate court panel, if you wanted to become a federal district court judge, and then you might want to elevate from there to the federal court of appeals, and then maybe be considered for Supreme Court someday. That's sort of a process, and so that's one of the reasons why some people get into those positions. It's not because of the money, but because they want the power that's involved behind being a judge. Now, the merit selection process in Missouri, named after the first state to adopt it in 1940, there's a retention election. It occurs after a probationary period. Few judges are removed from office during retention elections, but essentially they appoint them as a merit, and they put them on sort of a probation, and then they have to be elected at a certain point along the line. As a practical matter, they end up selecting the judges, and everyone goes along with the process. All right, so which system is best? How judges produced by one system differ from judges produced by another? It makes a difference if you want to be judged. If it's appointed by legislatures, more likely you're going to appoint former legislators. If it's an elected system, you're going to produce judges who are formerly local politicians. That's very, very common. And different systems will produce different judges who have similar backgrounds and characteristics. Elected judges react to public opinion more because if they don't, they're not going to be reelected. Again, one of the biggest problems in state judges is to have a criminal caseload. The reason why is because if you're going to make a mistake that's going to get you unelected, it would be something like letting a DUI suspect out on bail after the third DUI, and then they get in a car again and drive drunk and kill 5 people. And that's going to be all over the front pages. Judge lets somebody out who should have been kept in custody for years, that kind of stuff. That will get you unelected in the next election. And people remember those kind of things. So it's that kind of a problem. So similarity in the backgrounds, typically if you look at the actual majority of judges, they're male, upper middle class, white, Protestant, and educated, of course, because they're most typically lawyers. Even though most backgrounds, you don't have to be a lawyer. There's no requirement that you be a lawyer to be a judge. You would think there would be because you're making so many legal decisions, but not necessarily. And increasingly, judges are starting to resemble more diverse American electorate. So we're seeing more minority groups, more women, more people from lower economic classes, more from different religions and so on. But the educational requirement is pretty much the same. It makes sense. All right. Increasing diversity means now 26.2% of federal judges and 31% of state judges are now women. That's been up from what it was, the second half of the 20th century considerably. And of the 1,338 federal judges, there's 11% or so African American, 2% Asian, 7% Hispanic, 0.15 Native American, and 0.07 Pacific Islander. So you can see that there's at least some diversity coming in over the years. It's becoming more and more that way. And it's actually becoming more politically advantageous to appoint federal judges who are minorities, who are women, who are people that that would be of a diverse background, because they're more popular. And so you get more points as a politician when you do that. And so long as they're going the way you want them to go in terms of their decisions, why not? And so you're seeing that politicians have figured that out, and they figured that diversity is a good policy, but not necessarily because diversity is anything special to them, but because they get points for it with the electorate. All right, so diversity in the judiciary. More women and minorities are being appointed as federal judges, as we said before. They're attempting to draw conclusions about the differences in women's made on the bench. It's not very easy to do. There really does not appear to be much. If there could be anything that they might say is that women judges would tend, in courts where there is a lot of a process by which there's a compromise between parties, and the law calls for some sort of compromise, we see women doing more compromising and being more judicious in that area, whereas men would tend to be more cut and dried kind of thing, follow certain rules and go for it, whereas women might be more willing to look at real differences in the situations and make more judicious decisions. That's about as much as I've ever been able to see in my experience. Studies of female judges show that strong support of women's rights claims, of course, you might not imagine, harsher sentencing, particularly repeat minority offenders. They don't like that. They tend to be a group that likes law and order, and they don't take anything for granted in that situation. Let's discuss Judge Judy, that's seen on TV. There's a lot of other ones as well, very similar type of situations. She was, in fact, probably still is a judge in California, as I recall. Think about all the different shows that have been out there and all the different judges that have been there. What differences are there in the sentences handed down from male judges versus female judges, do you think? Do you think there's any difference? If so, what would be the difference, and why would you think that a female might rule differently on the case based on the male judge? And by the way, if you want to, you see some sexual assault cases, you might think there would be some difference, and that would be a good one to think about. Would you rather go before a male judge or a female judge? And why? Yeah, it may very well depend on the case, I would think. If it were me, I would be thinking about the case. If I had a case where I had a good, very, very, very good case, and it was only good under the law, but not necessarily good as an equitable type of situation, I'd go with a male judge because they tend to be more black and white. Female judges tend to be listen more to the equities or justice of the situation, and so I would probably say no. I would not go with a female judge under those circumstances. So again, depends on the case. How would you feel about going before Judge Judy? Do you like Judge Judy? Do you like how she makes decisions? Is there good things about what she's made or bad things? Have you ever disagreed with her decisions? That kind of thing. Let's do a close-up on Chisholm versus Roma. This was a case where the way of choosing judges through election was taken up into the federal courts based on a violation of the Voting Rights Act. What happened here was it wasn't really a matter of race. Well, it was a matter of race, I'm sorry. It wasn't really a matter of education. And the case alleged that electing judges from a multi-member district diluted African American voting strength and therefore was a violation of the Voting Rights Act. The defendant was the governor of the state of Louisiana. The Supreme Court concluded race is impermissible in drawing congressional voting districts, and so struck it down. So, how we elect judges can't be put into into situations where there would be unfair violations of the Voting Rights Act and diluting of votes of any minority group. Absolutely impermissible, and it was found to be that way in that case. All right, let's look at judging the judges. First of all, there is a concept called judicial independence. We think of judges as needing to be independent because they need to not worry about what people think sometimes, often, most of the time actually, if not all the time, and to do the right thing by the law under their particular case. And so that independence means they should be objective, and you can't be objective if you're not independent. But we do have unfit judges out there, and they do crazy things sometimes. You've seen some of them in your book. And so the question is, how do we remove an unfit judge without compromising this concept of judicial independence? So if we don't like their decision, that can't be the basis for removing a judge. It has to be something that's way beyond, something that would be within the idea of judicial independence before we can, or would even want to remove an unfit judge. All right, so we look at judicial performance and evaluation. And so that's part of what happens in whoever is deciding on whether the judges are doing their job as they should. And they look for acts of judicial misconduct. It could be, for instance, that judges are doing things that are simply not allowed. And I'll give you one example, one that actually happened. I think it was in Orange County, California. There was a judge that was trying a three-striker, so that person was likely to be going off 25 years to life. And what they do in those situations is they know that a person who's facing that kind of trial is likely to want to escape the courtroom, and they get really uptight about that. So it used to be that they would shackle them to an eyelet that's on the floor, built into the floor. But that became a problem because sometimes the jurors can see the handcuff on the ankle, and the person's handcuffed to the floor, and that's considered something that in our system we don't like to see because it tends to prejudice the jury against this defendant, because it's like this guy is so violent that they're worried about him running out of the courtroom, and that kind of idea goes through their heads, and then they're going to convict him. We don't want them to see that. So what they do is instead they put on this belt underneath the defendant's clothes, and it's got 50,000 volts of electricity, and the sheriff's deputy has a little wireless radio transmitter that when he pushes that button, it's going to set that thing off, and this person is going to go down on the floor and writhing like a fish out of water, and there's no way they're going to be able to get out of anything because all his muscles are going to be twitching in every direction. Well, what happened was this one defendant decided he wanted to represent himself. He became very disrespectful to the court. He kept talking back to the court. The judge got very, very upset with this guy, so upset that he ordered the sheriff to push the button and take this guy down to the ground. There was nothing like, he wasn't violent towards the judge. He was just being disrespectful and disobedient, in a sense of verbally disobedient to the court, and maybe contemptuous, but not a threat. And so what happened is the defendant's attorneys sued the sheriff for pushing the button. And the sheriff was found to be not liable because he was following a judge's order. The judge was found to be not liable because he's absolutely immune from any civil prosecution for anything he does as judge. But the Judicial Council reproved the judge for the misconduct of telling the sheriff to push the button on this person. Okay, so that's sort of one incident where misconduct was going on. It could also be where an attorney comes into court with a turban on, one of these religious hats that certain people wear in certain religions. Judges will sometimes order them to take it off, and they'll say no, and then the judge is reproved for religious discrimination, and that can happen. So we also have essentially state judicial conduct commissions that are composed of lawyers, judges, citizens from just ordinary citizens, and they investigate the cases of judicial misconduct, make recommendations to the Supreme Court if they find that there was misconduct, and then the final decision is on the Supreme Court in deciding on what to do with them. I mean, it's even up to removal. So a judge can be removed by a state judicial conduct commission through a cooperation with the state Supreme Court. And there's also Federal Conduct and Disability Act, allows for impeachment and removal of federal judges. So is judicial independence being undermined by this process of, going after them for misconduct? What do you think? Should we have it? Should we not have it? Should we allow judges to pretty much do whatever they want? Or is there a line which we can draw and say, no, you can't go past that line as a judge? Frankly, what I have seen, we better have the judicial councils out there. If judges think they can do whatever they want and they think they're omnipotent, then they will act that way. All right, let's look at some of the errant judges. There's a whole bunch of them. Luann Ballou, a magistrate in Tennessee, was removed from office ordering against the will of the parents a baby's name to be changed from Messiah to Martin because she believed the name to be a title that belonged exclusively to Jesus Christ. Well, that's religious discrimination, to say the least. Justice Oral Melvin was convicted in 2013 of conspiracy and corruption charges stemming from having used her sister's legislative staff to help orchestrate her election to the Pennsylvania Supreme Court. She was suspended from the court immediately following her indictment. She's facing removal from the office after a conviction. Melvin resigned from the court in 2013. In 2013, former Michigan Supreme Court Justice Diane Hathaway was convicted of bank fraud and sentenced to a year in prison. She resigned from the office during her 8-year term after the State Judicial Tenure Commission had suspended her. A veteran town justice in upstate New York was removed from the bench for jailing 5 defendants without affording them due process and just throwing them in jail. Basically throwing away the key, I guess, without a trial. Interesting. The Luzerne County, Pennsylvania Judge Mark Ciavella Jr. was convicted of 12 criminal counts, including racketeering, receiving bribes, and conspiracy for his involvement in a scandal that became known as the Kids for Cash. He and fellow Judge Michael Conahan accepted nearly $2 million in bribes from developers of juvenile detention centers and then sentenced juvenile offenders to those facilities for crimes that almost never led to incarceration. He was sentenced to 28 years in prison. In August 2011, Pennsylvania expunged more than 6,000 records of use that had been sentenced because of this judge. Chief Judge Sharon Keller of Texas Court of Criminal Appeals was charged with incompetence, violating her duties and casting public discredit on the judiciary for refusing to delay the closing of the court's office for an emergency appeal for a man facing the death penalty. The man was executed several hours later. That'll do it. Florida fined a Judge John Murphy $50,000 and suspended him for 120 days without pay for threatening a public defender appearing before the judge. A video of the incident revealed Murphy yelling, "You know, if I had a rock, I would throw it at your blank right now. Stop pissing me off. Just sit down." I said, sit down. If you want to fight, let's go out back and I'll just beat your ass. All right, you blank. You want to blank with me? Okay. Very interesting. These is, this happens. And these are kind of people that you wonder, how did they ever get appointed as judges? Pennsylvania Supreme Court Justice Michael Eakin resigned from the bench when it was disclosed he had sent racist and sexist emails to judges and attorneys in the state. Carroll County, Arkansas, District Court Judge Timothy Parker was removed from office for performing probable cause determinations for cases involving friends or former clients in which he lowered their bail or released them on their own recognizance. As of 2017, Parker is facing criminal investigation for exchanging favorable judicial decisions for sexual favors, prescription pills, and cash in a string of cases. Very nice guy. All right, so additionally, there are ethical constraints beyond those of lawyers. ABA has modeled canons of judicial ethics. For instance, one of the ethics is that judges should stay out of most social situations, meaning they should sort of be loners, because one of the problems that you have, especially in smaller communities, is if you get to know everybody, you may not be very practical because you're going to have conflicts of interest that are going to keep you from hearing cases. And you sort of don't want to become friends with any more people than you should, because you're going to end up not being as utilitarian as a judge as you need to be, because you're going to have to recuse yourself once you find there's somebody in the case that you know, and you should recuse yourself. So that's just one of the examples. It makes a judge's life kind of strange, to say the least. All right, that is it for Chapter 8. Again, if you have any problems with learning in Chapter 8 or any other link, feel free to email me or call me, and I'll be more than glad to help.